Our next speaker is Ms. Toby Kleinman, who, among other things, has been voted a New Jersey super lawyer. She is a New Jersey lawyer, but has consulted on legal cases in at least 40 out of the 50 states. She has edited, she has published in law journals, and she's a director of the advisory board to the Leadership Council on Child Abuse and Interpersonal Violence. She served as a professional liaison to the American Psychological Association and is invited constantly to give keynote addresses, lectures at colleges, and has appeared as an expert guest on network television. So we are most fortunate to have Ms. Kleinman with us.
Thank you. I got to do a little adjustment. Can I be heard? Okay. Well, first of all, thank you. I'm really honored to be here and to have been invited. I think this has been, so far, and I know we have a whole day ahead of us, very interesting for me. I know time is limited, so I'm going to just jump right in. I was asked to talk about a lawyer's view of family court evaluation, so I'm going to have, I think, a different perspective than you've heard from the psychologists so far. But when a trial lawyer is retained to represent anyone in a civil case or in a criminal case, a skilled and experienced lawyer usually can get a handle on the issues that will ultimately determine the outcome of a case. They can make a fair assessment of the probabilities of success on the very broad panorama of issues that are present and those that will be spawned during the course of litigation. And ultimately, a lawyer can, or usually can, reasonably predict and give advice and project potential outcomes. And they can also tell the client what to expect down the road. The one huge exception to this is in family court cases where there are issues of domestic violence and child abuse, or child abuse. To understand that skepticism, I should say, I'll talk personally, to understand my skepticism in the private sector and of those of us who do child protection work, you have to take a step back to really understand the setting in which these evaluators are appointed and that the powers that they are called upon to serve. The family court procedures are based upon laws where the procedures as employed and usually as ratified by the appellate courts, can easily and seriously undermine the intent of the statutes which have been designed for victim protection. And as they do so, they are undermining the letter of the law as well as the intent of the law. This is true for many reasons, but one of the most critical reasons, and because I have a short time, I can't go into most of the reasons, but one of the critical reasons is that in family courts, we permit what we refer to as relaxation of the rules of evidence and other court rules. The purpose of that rule was to permit, I think it was Marjorie Fields who said it was a social work background, to permit a more thorough understanding by family court judges of the dynamic of a family and the issues that were raised. It was never intended to be relaxed so the court could delegate its responsibility to a court-appointed evaluator, especially to untrained court-appointed evaluators. So in many ways, these courts act as they're acting are essentially lawless. The relaxation of the rules that they don't have to follow, undermining completely the intent and the letter of the law. The culture that existed today, when today's judges or their parents were growing up, so it was when they were raised, did not take domestic violence seriously. It was not until the mid-1950s, which sounds like a long time ago, but it truly wasn't, that actually all states removed women as chattel, property of their husbands, to do with how they pleased. In the 1970s, the theory of the law was based upon the tender years doctrine. But really what it was men didn't want custody of their children, so it wasn't an issue of the courts that they had to deal with. So tender years was really convenient. It was used by the courts, women got custody, men were not attacked, it was what they wanted. It was assumed by virtue of the fact that children were of tender years, that they would be with their mother. Into the 1980s, it became acceptable in society for men to become custodial parents. And it began to change theories, and theories developed to try to support this, a la Richard Gardner and parent alienation syndrome, which was and is still nothing more than a theory which is inaccurate. But it got traction in the courts, and it became a basis for courts to rule. So they did so with unqualified, unscrupulous court-appointed evaluators who relied upon this junk science to assert that a father should have custody of his children, and issues of domestic violence got set aside. Now, mind you, in the early 1990s, late 70s and early 80s at this time, domestic violence came to the forefront as an issue in the courts. And states had been enacting laws to protect women from spouse abuse. So this developed all at the same time. However, judges were never really trained on how to understand the dynamics of the abuse. They were trained in the law and on the law, and they continued to use discretion, make credibility determinations, and they often did so incorrectly, because real victims' behaviors are often counterintuitive, and perpetrators of domestic violence don't resemble the monster that the judges would have expected. So training was lacking, and the family court judges repeatedly gave fathers custody where issues of domestic violence were raised. And I'm saying this was, it still is true. The courts would appoint an evaluator. The judge would sometimes call these evaluators ex parte, or the judge would have given many hints on the record of how skeptical they were of a woman's motives. The court-appointed evaluator would certainly get the message, and the reports would be clear and decisive. Give dad the kids, teach mom a lesson. He's a more friendly parent. At the same time this was going on, children were seen as but pawns of the parents with no legal rights of protection. And this hasn't changed much, and I'm going to talk a little bit about that tomorrow, so I'm not going into it today. But after a period of time, in these cases, if the issue of child abuse arose, the court greeted those issues with even more skepticism, and more of the women herself began to look askance at the women, even worse than when domestic violence had been originally raised, because there was never proper training on how to discern whether or not child abuse had occurred, and it relied upon untrained, unqualified evaluators to, quote, assist the court. Thus, competent lawyers in the private sector who work in the field of child custody are very often distrustful of evaluators appointed by family court. The lawyers attached to Child Protective Service agencies, in a sense, are what I sometimes refer to as silent partners between the court, because the agency lawyer, knowing what will be done at each intersection of the case, each expecting of the other to do its part to lead the court to enter the orders which each could predict in advance, even as the evaluators are used to move the case forward. Thus, all too frequently, the issues of violence in the family, spouses and children alike, were not actually addressed in evaluators' reports in what we would want, which is a progressive manner, understanding the legislation as written based upon the scientific and informative knowledge of these issues of the day when they came before the court, because court-appointed evaluators were too often unqualified, and they simplify the custodial issues. I can't help but interject here, Andy. I thought your talk was a great talk, but I kept wondering, Since I've represented many, many victims and in many, many cases of child abuse, there's very frequently no corroborating evidence. And this is the ultimate of exasperation of actual victims. And it isn't sometimes until well after evaluators don't believe, after very scientific interviews and scientific evaluations, that something happens and something serious happens. So I don't find that quite enough. But it's part of an old culture which continues today. A case which should be the most demanding of the most credentialed, carefully trained, skilled forensic evaluators are often left to people who have little or no training in newly developed areas. And domestic violence and child abuse are the most critical of those areas. So John talked about the business, and I'm going to talk a little bit about that in a moment, but one of the problems that we see often with these evaluators is also the fact that many of them have had no previous training or experience or clinical experience which the population they're being asked to examine. Or they may have done some clinical work but rely on the courts to supplement their income, and therefore experience. They may have been doing years of custody evaluations, but never been trained on how to assess for domestic violence, never trained to assess on how to do child abuse. And absent the training, all the years of doing the custody evaluations is sometimes even more dangerous than having no experience with an honest and open-minded but educated evaluator. These evaluators are acutely aware that courts are using them to help simplify resolution of the most difficult of issues of a possible divorce, and to do so without a trial. I heard Andy talk about, oh, they settle more, they settle more, they settle more. Well, people who may have had years of experience doing custody evaluations may never have had the requisite training and experience, but the cases settle. They settle because that's what the courts are set up to have them do. The recommendations, more often than not, absent any testimony whatsoever, absent any cross-examination whatsoever, become the order for the court, even if it's in the interim of a case. And they often have misguided reasoning behind them. Some of those problems, such as domestic violence, are given short shrift because the evaluator has not been trained to assess. So, for example, whether or not, now somebody asked this question earlier, I believe of Marjorie, regardless of, I think it was Ricky who asked, whether or not domestic violence has ever been raised before. Even if it's been raised and denied as an order of a court, it needs to be assessed for if it's being raised. So you must have the requisite training. If a restraining order has been granted, then there's a finding. You have to, I agree with Marjorie completely, you must have that as a fact. But where you don't have the requisite training, what these evaluators ought to be doing, if they don't have it, is sending a woman for a battered woman's evaluation or a child abuse evaluation, someone with that very specialized training to give that information to them as a potential custody evaluator. But what they do, because part of this is a pecuniary interest, or a lot of it is they keep it to themselves. And the finding and the recommendation they make are without proper scientific foundation and are often then doomed for failure, even though the courts will enter their recommendations. The reports often explain away behavior or don't deal with it at all. They unscientifically blame the mother for a child's fear of the father, or excuse the stated fear of father because a child seems comfortable in the father's presence, often accepting blindly the same language used by the batterer as to why the woman is paranoid, delusional, and on and on. Most importantly, for some unknown reason, the actual knowledge base of the science itself is at that point completely disregarded, and when one looks at the resume of the evaluator, it would have made clear that that person had no specialized knowledge or training. In my view of reports and my reading of reports, I look for internal consistency. And these evaluators are often left at odds within their own reports because there's no trial or cross-examination. That doesn't come out, often until many months, sometimes years later, when a divorce is finalized. I hate the term high conflict because, at least in my personal anecdotal experience, it's never a high conflict because that talks about equal power, and we're not, when there's domestic violence, it isn't people of equal power we're talking about. We're talking about a power tilt. If we're talking about a protective parent and a child who is being abused, we're talking about a power tilt. So it isn't a high conflict circumstance. It's a domestic violence circumstance. There's only about 1 to 2% of all cases which are litigated, and we know that upwards of 90% of those have issues of domestic violence and or child abuse within them. Statistically, we also know across this country about 65% of the women who raise child abuse during a custody litigation lose their children. Something is wrong. So even when we have testimony, which often happens very late on in the game, the judges end up relying upon evaluators who admit their lack of credentials. They shouldn't testify on the custody at all if they had not training for sex abuse and domestic violence, if those issues were raised. And they have done the evaluation in a subpar way and not acceptable to practice. I can't tell you how many reports I've read where sex abuse was raised, and yet a young child is brought to an interview by the named perpetrator. What? I mean, I know that as a lawyer. Take a deep breath, I'm sorry. They make assumptions about the fear of the child's fear, contrary to what is known in science about children's reactions. They ignore disclosures of children and put them on into they put them onto the protective parent, accusing the parent of coaching. They ignore the science, that rapport building is critical, and it's the initial first step before a child would disclose to you. And instead of spending the time to build that rapport and taking the time to do so, they assume a lie or a cheat or a fraud, and they become part of the attack machine, accepting the other parent's formulation. I query, in what other realm of the law is a denial of a crime accepted as true? And where else do we ever move on as though it is true? There isn't a single area in the law, except with child sex abuse, except with domestic violence. There are other issues as well. The notions of reunification of the family or reorganizing the family to allow quality time with any parent who expresses an interest overrides plain risks of danger and facts which show history of danger, all of which are always present where there's been domestic violence. The idea of quality time with an abuser is romanticized, and the bar is set ridiculously low for contact and an opportunity to continue to abuse children and coerce them in the entirety of the circumstance. And this is so because the Constitution of the United States has been interpreted to mean that parents have a right to parent. It's so because looking at a man accused of battering when he's standing before you in a three-piece suit is counterintuitive to believe that he could do that. And there isn't proof, there are no pictures, not necessarily any broken bones. It's ignored because looking at that man accused by his child of heinous acts of sexual abuse, it's easier to believe that he didn't do it and the wife is making the child say it. And I'm reminded of a father I cross-examined in a courtroom years ago about heinous acts against the child of his first wife. He was then married, and the issue was involving another child. And as I cross-examined him, I had an affidavit of that child, and I questioned him on each act. And I must say, I had a bit of a hard time containing myself as I asked each question. And he admitted all those heinous acts. Pornography, nightly basis. Rape, nightly basis. From the time the child was 4 years old. He testified, he actually testified, that the statute of limitations had run on these crimes. And of course, he knew that. He was a lawyer. The crimes were committed in another state. I almost vomited, sorry. I mean, I didn't mean to be vulgar here, but it was really hard as he continued to admit, and I persisted and asked. And he cried. He cried. And he said, as he looked at the judge through his crocodile tears, "You know, Your Honor," soft voice, "when I wasn't doing those things, I was a really good father. 99% of the time, I was a good father. And I didn't do anything to this child," the child we were there in court about. And the judge looked at him, and I mean, I still cannot get over, this was a presiding family court judge and not my own state, another state. And he said, "I believe you, Mr. So-and-so." Mr. So-and-so was a lawyer working for the federal government. Truly, had he not dropped dead running, the court may very well have given him visitation, but as it was, we had it stopped, and he died. So, where a court seeks to interfere with the parental rights, the child's safety must be in jeopardy, and therein lies the rub. While a child's safety is supposed to trump the parent's rights, the question very often for the court becomes a quantitative analysis of risk of harm. And most judges just don't get it. And it's within that framework that they're appointing evaluators. Critical to all of this is the fact that the children have no standing to object to who evaluates them. No standing to object to any recommendations or any orders that are entered. Laws that are designed to protect them are ignored. They can be ignored because it's relaxed, and they are ignored. And courts, in their appointments, can override or ignore expert opinions where there are safety concerns expressed and or issues of lethality of abusers, even when they exist, even where an evaluator has opined that there is a risk of danger to the child. Thank you. Courts, thank you. Courts universally place the safety of the child as a subset to the litigation between the parents in a divorce case. Safety is legislated as paramount, but the only way to do that is ignored. That is, child abuse and safety should be heard before any other issue gets determined. Rules of evidence must be followed and adhered to as to qualifications for testimony on issues of expertise of the person testifying, and that court should not be subjective in its approach to that science. Agencies with investigative mandates of child abuse also have a mandate to protect children. Simultaneous to that, they seek to ensure the sanctity of the family unit. Thus, they are the prosecution and the defense. And the abusive parent is essentially given protection in an unarticulated and broad parental interest in the recommendations to the court. So even where protective service agencies are brought in, their dual mandate conflicts with their overriding caution of child safety. If these same children were victims of stranger violence, funny thing here, I dare say these same people would express outrage. not seek to rejoin a relationship between the adult and the child. The lawyers who handle those matters then are also silent partners of the court system. So where family courts are permitted to relax the rules purportedly to protect the safety, in actuality these rules are often used to appoint and then permit unqualified, unskilled people to testify, thereby perpetuating the harm to children. The Child Protective Service lawyers know this and sometimes rely on it to protect children, and at other times they use it to dismantle their protection. It can only stop if it completely stops being permitted. Family courts perpetuate a different set of court rules and rules of evidence. The breadth of the problem in court, as I have explained, frequently centers on the lack of qualification. In part because if they hear no broken bones or see no broken bones, the courts don't necessarily understand it. One has to wonder, Joe Paterno, we recently had a major scandal, did not report what he knew. Did he do nothing because he didn't think it was bad? Did the man who told Paterno ignore it himself and not go to the police because he believed because he was afraid? Afraid of what? Of power? Imagine the power to a child. A parent's power over a child. Imagine that power dynamic with a battered spouse or any spouse worried for a child's safety. And then they're faced with the court appointing someone unqualified, never sending it to a prosecutor, and blaming the mother for coaching. Why would anyone come forward? These mothers are brave. These mothers need to bring this all out in the open, and the system and the policies need to change, because children's rights do not exist in any substantive way that we would equate with stranger violence when a child discloses abuse or when a woman is a victim of violence by a spouse. An abusive parent does not face the same rigors of evidence as exist with stranger violence. I don't know, do I have 5 minutes? Can I take an extra 5? Somebody there? Okay. In criminal court, because there is no confession, doesn't mean there won't be a prosecution now, does it? But in family courts every day, we drop the issue because the perp says, I didn't do it, Your Honor. She's lying. We know that clinical interviews are not really scientific. And so if you're dealing with an unqualified expert and they're not coming under any scrutiny, what then do you have? There's no crime, there is no other crime where someone interviews a defendant, relies upon a denial as sufficient to fail to prosecute. But unqualified experts rely, and then the courts rely on them. Very often, the women are coming apart at the seams. They're at loose ends, often angry, appropriately, at the spouse and at the court. Many of these evaluators are unqualified to even diagnose post-traumatic stress disorder. And I have come to find that they're diagnosed as borderline and paranoid, because nobody really looks at it. The people are unqualified. So where a woman's reactions are actually adaptive behaviors or part of post-traumatic stress, and as a result of years of battery, the evaluator finds the abuse easier to deal with and relate to a man who's smiling up at them than a woman who is at loose ends. The unqualified evaluator shifts their focus to how to promote a better understanding between the parents, when we would never have two strangers ever speak to each other after violence occurred between them, nor would we ever allow our child to be with a neighbor again if a neighbor had abused the child. So safety for the child has often shifted to go along, get along, ignore a child's pleas, the mother is told, or you'll lose your child, you'll lose custody. Indeed, the impact of the violence, much less the violence, have all been ignored. And then courts become even more skeptical if there's an agreement and the issues get raised later, because there's already been the belief that the abuse didn't happen, everything is based on that false belief. And the predisposed thinking takes hold, and the process itself starts not with the question of what happened here, but with confirmatory bias that it didn't happen, and it sets forth why is she raising these issues rather than openly exploring what actually happened. And they stop contact with the mother, where they never would have even suspended visitation with the father when a child made a disclosure. Am I there? Okay, I mean, I can stop at any point. I would just say, in closing, if I can have final, is I truly think that when there are three things that we need that are critical. I mean, we need massive reform. I've said a lot of what I've talked about, but the final piece is that the standards are not the problem. It's really the implementation of the standards and the accountability that goes along with that. And I thank you very much.